स्वागत है दोस्तों आपका हमारे YouTube चैनल पर। और इस YouTube चैनल के माध्यम से आपको मिलती है शॉर्ट एंड डिक्टेशंस, फ्रेजेस और आउटलाइंस। अगर अभी तक आपने चैनल को सब्सक्राइब नहीं किया है या पहली बार विजिट कर रहे हैं हमारे चैनल पर, तो चैनल को सब्सक्राइब जरूर कर लें। साथ ही बेल आइकन को जरूर हिट कर लें, क्योंकि जो भी हम डिक्टेशन डालते हैं उसका नोटिफिकेशन बेल आइकन को दबाने से, बेल आइकन को हिट करने से ही आपके पास पहुंचेगा। और दोस्तों, अगर आप हमारे फेसबुक ग्रुप से या व्हाट्सएप ग्रुप से या आप टेलीग्राम चैनल या ग्रुप से जुड़ना चाहते हैं तो उसका लिंक डिस्क्रिप्शन में है। साथ ही हम जो मैटर लिखने वाले हैं इसका जो लिंक है मैटर का, वो भी आपको डिस्क्रिप्शन में मिल जाएगा। साथ ही साथ आपको ये जो डिक्टेशन हम बोलने वाले हैं, इसका जो स्पीड है वो है 100 वर्ड पर मिनट, और एक 80 वर्ड पर मिनट के डिक्टेशन हम इसमें डाल चुके हैं, वो आप देख सकते हैं इससे कुछ देर पहले। तो चलिए शुरू करते हैं। 5 seconds. The defendants pursued the matter further and filed second appeal in the High Court at Madras. The High Court admitted the second appeal on the following substantial question of law: whether the same judge can dismiss an appeal on the ground that he has already rejected the appellant's case in an earlier appeal against different parties in the absence of pleadings of res judicata or estoppel by judgment by neither of the parties, especially when the issue is pending for decision before the High Court by way of second appeal. By impugned judgment, the High Court allowed the appeal and set aside the judgment and decree of the two courts below, and in consequence dismissed the suit, giving rise to filing of the present appeal by way of special leave in this court by the plaintiffs. The short question which arises for consideration in this appeal is whether the High Court was justified in allowing the defendant's appeal and in consequence dismissing the plaintiff's suit, which was decreed by the two courts below. Having heard the learned counsel for the appellants and on perusal of the record of the case, we are inclined to allow the appeal, and while setting aside the impugned judgment, remand the case to the High Court for deciding the appeal afresh on merits in accordance with law, after framing appropriate substantial question of law as indicated below. Before we examine the facts of the case, it is necessary to see the scope of Section 100 of the Code of Civil Procedure 1908, hereinafter referred to as the Code, which empowers the High Court to decide the second appeals. Indeed, it is explained in several discussions of this court, and thus remains no more res integra, provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear, for reasons to be recorded, the appeal on any other substantial question of law formulated by it, if it is satisfied that the case involves such question. Para. Subsection 1 of Section 100 says that the second appeal would be entertained by the High Court only if the High Court is satisfied that the case 8 involves a substantial question of law. Subsection 3 makes it obligatory upon the appellant to precisely state in memo of appeal the substantial question of law involved in the appeal. Subsection 4 provides that where the High Court is satisfied that any substantial question of law is involved in the case, it shall formulate that question. Para. In other words, once the High Court is satisfied after hearing the appellant or his counsel, as the case may be, that the appeal involves a substantial question of law, it has to formulate that question and then direct issuance of notice to the respondent of the memo of appeal along with the question of law framed by the High Court. Subsection 5 provides that the appeal shall be heard only on the question formulated by the High Court under subsection 4. Full stop. Thank you.